से 15 तक वो काम किए कि नहीं किए?
काम किए सर, अलग अलग जगह पर थे, जैसे एनएसएस के कोऑर्डिनेटर यूनिवर्सिटी में।
Why salary is not
The wife is now on the call.
in pay? He is a regular, the deceased employee is a regular holder of the post of lecturer
Yes.
in 2006.
Yes.
There is no reasons why you are not paid the salary for the period from 2012 to 2015. In that event, he is entitled. In that, what was the relief?
The last order of that
Deceased lecturer was not entitled to be adjusted on 17/1/2006. Where is the regularization? It is not a regularization, it is an adjustment.
It's absorption order, no?
Show us the absorption order.
But the language,
Don't use the word which is not there.
but they say that
It amounts.
For admission serial number 9, Sanaz Begum versus the state of Bihar and others for the appearance, Ms. Anita Kumari.
was the writ petition was filed challenging was in Section 21, page 78 of the brief.
Yes, sir.
After the death of the original appellant, the wife is now on the call.
Yes, madam.
as per your lordship last order, the Registrar of Bajanthri University is present in the court.
Ask him whether petitioner appellant was observed in service in the post of lecturer, and whether she has worked during the period from 2012 to 2015. Now you are asking him. Sansa Begum.
Abdul Latif.
Dr. Abdul Latif was the original appellant.
All right. Yes, sir.
Yes. आवेदक
इसमें इनका एब्जॉर्प्शन जो है कब हुआ?
एब्जॉर्प्शन 2006 में हुआ। अग्रवाल कमीशन के 4th लिस्ट में उनका नाम था। उसमें यूनिवर्सिटी ने डिसाइड की जिनका नाम है सबको एब्जॉर्प्शन किया जाए, तो उसमें उनको लेटर दिया गया 2006 का। लेटर नंबर GS KBJ बॉटनी।
ठीक है, उसका कॉपी आप दे दीजिएगा अभी।
On record
है। अच्छा,
let's have file is detailed synopsis.
Ask them, please.
just a minute, just 2012 से 15 तक वो काम किए कि नहीं किए?
काम किए सर, अलग जगह पर थे, जैसे एनएसएस के कोऑर्डिनेटर यूनिवर्सिटी में।
Why salary is not in?
वहाँ पर थे वो।
फिर उनको उस पीरियड का सैलरी क्यों नहीं दिए?
सैलरी माननीय न्यायमूर्ति SV सिन्हा का जजमेंट के आलोक में जो 2014 में आया, उसके बाद मैं वहाँ उस समय में रजिस्ट्रार नहीं था। उस समय के रजिस्ट्रार और वाइस
वो जजमेंट आया तो इनका क्या हुआ? इसमें क्या आया उनका?
जजमेंट पे उनके क्लेम को डिसमिस किया गया, जो क्योंकि 1A लिस्ट जो माननीय अग्रवाल कमीशन के द्वारा दिया गया था, उस सैंक्शन पोस्ट में उनका नाम नहीं था।
किस डेट को इनको रेगुलर किया गया था? रेगुलेशन का डेट क्या है?
17 जनवरी 2006।
और इस ऑर्डर को आप लोग क्या किए बाद में? जब SP सिन्हा साहब कमीशन का रिपोर्ट आ गया, उसके बाद ये ऑर्डर विड्रॉ किए, कैंसिल किए, क्या किए इसको?
विड्रॉ नहीं किए, ना कोई टर्मिनेशन हुआ।
नहीं, कोई टर्मिनेशन हुआ।
Salary. That is the case, you pay the salary.
Yes, order please.
Calculate salary and pay. He is a regular, the deceased employee is a regular holder of the post of lecturer
Yes.
in 2006.
Yes.
There is no reasons why you are not paid the salary for the period from 2012 to 2015. In that event, he is entitled.
And even thereafter, till his death.
No, thereafter it has not been paid.
No loans.
Up to what date?
Up to death.
What is the date of death?
He had been paid the salary, 50% of the salary.
Why, sir? What is the reason? He is not related to you. There is no employer and employee relationship.
30/10/2017.
30?
High Court.
10/2017.
No, but you have worked.
Yes, sir. I was working.
न्यायालय में केस पेंडिंग था इसीलिए उनका पूरा
Is there any prohibition?
He died, Lord's Son.
Have you asked you to not to pay the salary? Then, merely pendency of litigation for 30 years, you don't want to settle his salary, but you want to extract work.
2015 में माननीय न्यायमूर्ति मिहिर कुमार झा जी का जजमेंट आया, उसमें भी उनको क्लेम को खारिज कर दिया गया.
Now, what is the reason assigned by the single judge?
Lord, sir, may I explain, Lord?
Because the appointment was after the cut-off date.
But you are not withdrawn, no? You are not disputing his appointment. Now, why state government has not given the fund?
स्टेट गवर्नमेंट फंड नहीं दिया.
Who is appearing for state?
What is that? You are not found. It was decided by the previous commissioner.
What is the date of
30th of April 1986.
30th of April 1996 is a cut-off date. 86 is the only set. They are not withdrawn the No, after introduction of Sinha commissions, action has been taken. What
2014 में रिजेंट ऑर्डर,
is the date of commission of Nissan?
स्टेट गवर्नमेंट ने रिजेंट ऑर्डर पास किया था. इसमें माननीय न्यायमूर्ति एसबी सिन्हा के जजमेंट के आलोक जजमेंट आने तक
SB Sinha commission report is dated what?
30th November 2014.
This has been implemented in respect of deceased employee.
Because his
ऑर्डर प्लीज.
implement हुआ था judiciary में, उनका decision तो dispute.
Appointment.
हाँ, डिसमिस.
Because the state has not given the fund, that is why university is not able to pay.
No.
Then pay from your pocket because you have committed mistake.
Appoint the petitioner, that the college appointed the petitioner. And university is bound to
Who
work.
is appearing for college?
And university is bound to work according to the state, your lordship, until state will not.
No, who is appearing for college?
State This not appear to the
Principal KB Jha College.
Your Lordship.
Now this college is under Purnia University, Purnia.
No one is appearing on behalf of KBJ College, Your Lordship.
What was the date of appointment of this appellant?
Your Lordship,
Lots
notice
was
has-
appointed not in on
Date of appointment is
86 lots.
Date of appointment is 12 May 1986 and the date of joining is 8 July 1986. And cut-off date is
12 May
12 May 1986, Your Lordship.
12
The
May
petitioner was appointed.
1986. Lots I have filed a detailed synopsis in this case, which my lord may find was the last of not the in which every document is there. Last lots in the form of petition lots at the end of the file.
Were you party in the earlier litigation?
In which lots?
Were you party in the earlier litigation? CWG 10820 of 2014.
No lots.
You are not party.
Yes, lots. It was filed by me lots.
Filed by you.
My lots. 180.
No, 10820 of
18204 of 2000.
10820.
No, in that, what was the relief?
The last order of that case was that Your Lordship, he said that the final decision is rendered by Justice S.B. Sinha Commission, and after 13 days, the S.B. Sinha's commission order was passed, and it was and the claim of the petitioner was dismissed in that.
I'm sorry, Lords. Again, they are not correct. Lords, the report is there, Lords. The order passed by S.B. Sinha Commission is there on record as an annexure. Lords, in the last,
Regularization order?
yes, Lords, annexure.
This is the order of Your Lordship.
Regularization order? Where was the regularization?
It should
No,
not be signature.
not the court order. Regularization order.
Yes. Annexure, Lord. Annexure 8, page 45 of the writ petition.
Of the writ petition.
Lords. May I request my lord to turn to the last of them, Lords, the LPA file, where
No, the regularization order has been issued by whom?
by Lords the Registrar Lords, Kul Sachiv,
Huh?
Kul Registrar Lords,
Register of what?
under the orders of the Vice Chancellor, and in view of the decision of the Senate and the Syndicate, after the approval of the Senate and Syndicate, page 45 of the report. And in 2011, Lord, he was granted promotion also.
Promotion 2000?
11.
What promotion?
Lord's
promotion to associate professor.
associate professor.
That is prior to commission, commission report.
Lord, the SB Sinha Commission only said that since the issue is beyond the term of reference,
No, whatever it may be, sir, the cutoff date is 30th April 1986.
Lord,
As on that day, you are not appointed.
Lord, I have placed on record the agreement of the university with the college. And in that agreement, it is said Lord, that till the date of the college was taken over as a constituent unit, all teaching and non-teaching employees would be absorbed in service, whether appointed on sanction or not recommended post. That agreement is also on record.
That is regularization.
Adjusted on the 17th of 2006 by order of Vice Chancellor.
But may I say one thing?
17th April 2000.
Sorry, April, 17 January
17 January
2006.
2006. Regular.
Word adjusted in service.
Not amount of regularization. Where is the regularization? It is not a regularization, it is an adjustment.
It's absorption order, Lord.
Show us the absorption order.
Lord, the language,
Don't use the word which is not there.
Lord, they say that
It amounts to adjusted.
under 4114 of the University Act, Lord, 1976, that he is adjusted against the sanction post. His services, Lord, I'm reading, Lord, Mani Sarvoch,
Whether adjustment amounts to regularization.
Lord, it is the term which they have used for everyone. For everyone they have used this term.
Then using such word is wrong. It will give wrong interpretation.
Yes, Lord, absorption. Agarwal Commission has also found, Lord,
Where is the absorption notification?
Lord, this is the notification what they have issued.
General notification, sir. For example, ad hoc employees were recruited as a lecturer. After 10 years or 8 years, they are entitled to regularization or absorption. There must be a general policy decision of the university or state government. Where is that policy?
Bloods, they were absorbed in or regularized, whatever may be bloods. It was under the recommendation of Justice S.C. Agarwal Commission and the order of the Honorable Supreme Court. There was no policy decision of the state government or the university to absorb certain category of employees who were working against the sanctioned or recommended post. And Lords, the petitioner in the list prepared by Justice Agarwal Commission, my Lord would find the petitioner's name in the category of those lecturers who were found fit for absorption.
No, or consider.
No, even sanction post. No. No, this equivalent entering. How is it for this case? You have quoted wrong provision. That is not correct. This is agreement.
May I request, my Lord,
Absorption. In the later Puma, he will be Puma. That's on there. I don't know.
may I request, my Lords, to have a glance of
He is entitled for payment.
Treated as regular employee.
the salary from 2012 to 2017. How to overcome the permission to teach? They'll take into also correct report. Some this is not correct. Prior to 30th April, this case was prior to. No, this is in the report, no? After the commission report. No, this is commission also. Then what is the outcome? SDA commission report will not assess the disease. This is what that commission report. This document is indicating. No, that is the document. That's why model wanted to okay, the action is no document.
That's only one thing I was.
Hello, still you have objection?
No. I have not.
The person to our order dated 4/2/2023, so and so, is present in the court. Today he has clarified relating to his the deceased employees absorption and the fact that he had worked during the intervening period from the year 2012 to 2015
2017 till his death.
and continued to work till
His death on 11/10/2017.
11/10/2017. You can bracket the date on which he died. Yes, sir. Deceased Dr.
Abdul Latif.
Latif
My lord.
was appointed as a lecturer on ad hoc basis on 12/5/1986. In the year 2001, university has taken a decision that such of those ad hoc employees are entitled to absorption if he or she was appointed prior to 30th April 1986. Ignoring the cutoff date of 30th April 1986, the respondent university adjusted a deceased employee, a deceased lecturer, that he is a regular holder of the post of lecturer on 17/1/2006. Thereafter, was not provided he has not been paid salary. No, he has earned promotion to the post of associate professor the year 2011. So thereafter, during the year 2012 to 2015, he has not been paid salary. Therefore, he has filed a writ petition 10442 of 2015. It is submitted that even thereafter, till his death, salary has not been paid.
Next, learned counsel for the appellant submitted that once the deceased lecturer services were regularly treated as regular with effect from 17/1/2006, there is no point in revisiting whether deceased employee is entitled to regularization or not with reference to cutoff date as 30th April 1986, read with the fact that appellant was appointed on 12/5/1986. It is further submitted that even at the time of granting promotion to the post of associate professor in the year 2011, university, college / universities / state have not raised any objection relating to regularization / absorption of the deceased lecturer. On the other hand, in the year 2015, abruptly, he has been denied salary attached to the post held by him. Salary attached to the post of associate professor has been withheld only on the score that his initial appointment to the post of lecturer has not yet attained finality in regularization / absorption with reference to the cutoff date that 30th April 1986 as per the policy decision read with the appellant's appointment on 12/5/1986. Next, single judge has not apprised the facts of the case with reference to the fact that the appellant has been adjusted against a sanctioned vacancy with effect from 17/1/2006 to the cadre of lecturer, even though word of regularization or absorption has not been incorporated in the 17/1/2006. On the other hand, one has to draw inference that it is a regularization. No, for the reasons that respondents have promoted appellant to the post of associate professor the year 2011. In the result, out of the line, single judge is liable to be set aside and a deceased employee is entitled to all monetary benefits from the year 2012 till 2017 with reference to the post held by him, namely associate professor. Per control and next per control and counsel for the respondents. Respondent state that there is no representation, and so also
I am appealing for.
college principal. What is that you are going to assist?
No, my lord.
Only collecting fees.
No, my lord.
Then
सो लेट हो गया था जुड़ाने में, तो जस्ट हम पता चला था, हम हजूर क्वेरी कर रहे थे.
all right. Any submission?
My counter is there on the record.
So you want us to look into it? Then
Not at all, my lord, not at all.
then what you tell us?
My counter is there, my lord.
All right. At this stage, Mr. So and so counsel entered appearance and submitted that county may be taken note of. He has not read the paper and make his submission in the matter. None appears for the principal of the college, a respondent. Heard the learned counsels for the respective parties.
Notice has not been served to the KBJ college.
Huh?
Because notice has not been served to the college.
Why notice has not been served?
That's why his college is not informed in this matter. College.
No, the next paragraph, learned counsel for the university reiterated the factual aspect of the matter. On the other hand, they have supported the order of the learned single judge stating that there is no regularization order in favor of the appellant, and the fact that litigation was pending consideration, therefore arrears of salary of the deceased employee was not settled. To support the learned counsels for the respective parties. The appellant, deceased employee Dr. So and so was appointed on ad hoc basis against one of the lecturer posts on 12/5/1986. State government, official respondents have taken a policy decision to regularize such of those employees who have joined any of the posts prior to 30th April 1986. They are entitled to regularization. Obviously, a deceased Abdul Latif is not entitled to regularization in terms of the policy decision, as he has been appointed as a lecturer on ad hoc basis on 12/5/1986, that is a few days after cut-off date. On the other hand, university has taken a suo motu decision while adjusting the deceased employee, a deceased lecturer on 17/1/2006, adjusting him against one of the lecturer posts. So thereafter, he was extended benefit of promotion to the post of associate professor in the year 2011. Due to various controversy, there were certain reports like Justice S.B. Sinha Commission, etc.
Justice Agarwal Commission.
Justice Agarwal
Commission.
Agarwal Commission. Which is first one?
Justice Agarwal Commission.
First Agarwal, then S.B. Sinha. The commission report and the policy decision of the official respondent in the year 2001 may not assist deceased lecturer. However, university have taken a decision to readjust deceased lecturer against one of the lecturer posts on 17/1/2006. It is to be noted that if the official respondents have committed any error that deceased lecturer was not entitled to be adjusted on 17/1/2006 with reference to policy decision of the official respondent issued in the year 2001, read with the commission's report, and further read with the cut-off date notified as the 30th April 1986. So in other words, such of those employees who are appointed on ad hoc basis prior to 30th April 1986 and such of those employees are alone entitled to absorption / regularization. It is admitted fact that deceased Abdul Latif was appointed on ad hoc basis as a lecturer on 12/5/1986. However, none of the officials have taken note of that regularization of deceased Abdul Latif was contrary to the policy decision. Even to this day, none of the official respondents have taken any decision either to withdraw the readjustment of deceased employee services against a lecturer post on 17/1/2006. Even to that apart, there is no cancellation or modification, and further disturbing the promotion order issued in the year 2011 to the post of associate professor. Therefore, one has to draw inference that there were serious lapses on the part of the official in not taking timely action. In the absence of withdrawal or cancellation of 17/1/2006 University's decision to readjust the deceased employee against a lecturer, and in not withdrawing or cancelling the promotion order issued in the year 2011 to the post of associate professor, and continued the deceased Abdul Latif in the post of associate professor till his death
On 11/1,
till his death
on
so and so
11/10/2017.
11/10/2017.
Right.
The appellant is entitled to all service benefits from 17/1/2006 till 11/10/2017. The learned single judge has not apprised in not withdrawing or cancellation of 17/1/2006 order relating to readjusting the deceased employee against one of the lecturer post in the college, read with promotion order to the post of associate professor in the year 2011. In this paragraph, one single judge has committed error. Accordingly, the appellant has made out a prima facie case so as to have the benefit of service as well as monetary benefits during the intervening period from the year 2012 to 11/10/2017. The same shall be calculated and disbursed in favor of the deceased employee, in favor of the legal heir of the deceased employee within a period of 4 months from the date of receipt of this order. Failing which
Also, kindly give the direction.
failing which the appellant is entitled to interest at the rate of 8% per annum on all arrears amount in the light of Apex Court decision in the case of Vijayam of India 2001 9 SCCs page so and so. If there is any dispute relating to availability of funds with the college or a university, the state is hereby directed to provide fund to the university to comply the order of this court, for the reasons that official respondents might have committed error, even assuming that if they have committed error in readjusting the deceased employee Abdul Latif on 17/1/2006 and granted promotion in the year 2011 to the post of associate professor, still deceased employee is entitled to regularization under the apex court decision in the case of Uma Devi. So and so, for the reasons that deceased employee had completed 10 years of service. Deceased employee has was appointed on ad hoc basis by competent authority, he had been readjusted by the university on 17/1/2006 and further he has been promoted to the post of associate professor in the year 2011.
This college falls under Pune University. So can you give the college?
KVJ college is under.
Now
Kindly give direction
to
to
the Pune
Pune
University.
Registrar Pune University.
But they,
Register.
एक्चुअली वो कॉलेज अभी पूर्णिया यूनिवर्सिटी के अंडर है, तो
You are not representing Purnia University.
lots,
Then you are appearing whom?
और बीएन मंडल यूनिवर्सिटी को देखो.
All right, you pass on the file to the concerned university.
lots, that is not required because it has been
For
bifurcated.
that,
Now, bifurcated.
if they are still agreed, they can take up this matter.
Lots, there are other certain death come retirement benefits. Therefore, those benefits also they may consider.
Go and make representation, sir.
Okay. Also, if my lord would indicate something, but there, it will help me. Lots, I have been fighting lots.
And counsel for the appellant seeks retired benefits or death benefits of the deceased employee in favor of the legal heir. Such a relief cannot be granted, since it is not the subject matter of litigation. However, reserving liberty to the concerned appellant or a legal heir to approach the concerned authority in seeking other benefits, if any.
Senior Lieutenant Manoj Kumar Sinha versus Jila Parishad Hunters for the appearance